it is going on. And in light of our situation with everyone being remote, again, we've tried to take that part of it very, very seriously. Excuse me, I'm going to do one more thing real quickly, and then I do not need that since I'm in the courtroom. Okay, we'll introduce ourselves in just a moment. I'm going to start off by telling you what I think we're hearing today, and then we'll decide what order we're going in. And that was not an easy task. So here's what I got. I think we are hearing motion for summary judgment filed on June 24th, 2020. I think we're hearing a motion for declaratory judgment filed on July 31st, 2020. I think we're hearing a motion to dismiss or for partial summary judgment filed on July 31st, 2020. And I think we are hearing a motion for entry of injunctive relief filed on August 26th, 2020. There is one additional motion that was filed last week for attorney's fees, and I don't believe that's ripe for a hearing. What do you, and I'll start with Ms. Dutchman, what do you think we're hearing today? But just give me a list of what we're hearing. Don't start arguing.
I will not start arguing, Your Honor. I agree with your representation and the court's understanding of what is being heard. We did file a motion for attorney's fees in conjunction with our response to the motion for injunctive relief, but we are fine putting that aside until the court determines that it's ripe for argument.
Okay. All right, Mr. Riggers, what do you think we're hearing?
Your Honor, I think you did a great job of identifying the issues we have to hear, and that's the order and the dates that I have indicated as well.
Okay, well, we've started out on a good note, so I think that probably, unless you feel strongly otherwise, the best thing to do is to go in order. So just to note that present on the call today, I call it call, present on the Zoom teleconference today, we have Ms. Dutchman, Mr. Riggerish, the Ellises, myself, Ms. Cummings, our staff attorney, and our court reporter, Ms. Ingram. So Ms. Dutchman, at this time, I'll turn it over to you.
Thank you, Your Honor. If the court recalls, we had a hearing for injunctive relief back in June, I believe it was June of 2020. And we addressed a lot of the issues that are the same issues being presented on our motion for summary judgment. In fact, I think the court indicated that while it was denying injunctive relief, it felt that these were issues that were appropriate for summary judgment. And so here we are to address the two provisions in the operating agreement. And I don't want to go into more detail than necessary depending on the court's recollection of the provisions, but just to make sure we have a clear record, there is an operating agreement that was in existence between Ms. Sarah Ellis and American Sun Control, which is owned by Elizabeth Brand. She goes by Lisa. And part of that operating agreement involved a distribution provision that occurs in the operating agreement just after section 4.2.2.3. It is not enumerated, and so we've referred to it throughout the litigation as the distribution provision. And the other provision at issue is the transfer of Ms. Ellis's interest to a family member and subsequently to an affiliate, which was to her husband and then to SYV, who is a co-plaintiff. And Those are the two provisions that we discussed at the injunctive hearing. And those two provisions are very specific, and they tailor the exact circumstances surrounding each event that are up for debate right now. What I'd like to point out is that the defendants have tried to attack our entitlement to summary judgment by referencing more general provisions that give Ms. Brand, as owner of the majority member ASC, discretion to make distributions and discretion.
I'm sorry. Jill, repeat that again.
Yes.
Repeat the last sentence. The majority.
The defendants are advocating that there are provisions which in our minds are much more general and not controlling that give Ms. Brand, as owner of ASC, which is the majority member of the company, I call American Lighting Control the company, just to be consistent throughout. Otherwise it gets confusing between ASC and ALC. So Ms. Brand owns ASC, which is the majority member of the company. And there are provisions that are general that give her discretion over certain cash distributions and over certain transfers of interest. But the defendants have also injected into this case an issue that revolves around self-serving affidavits filed by Ms. Brand that would allege that Ms. Ellis acted in a way that constitutes cause as defined in the operating agreement, thereby triggering something called involuntary withdrawal. Now, the problem, as we set forth in our response to their motion, which I know is not an issue, but it does come into play as far as why we're entitled to summary judgment, despite their argument, is that there is no mechanism in the operating agreement that determines how cause comes into play, who alleges it, how it's established, when it's established, and how it then would trigger an involuntary withdrawal. There's no notice mechanism for involuntary withdrawal. There is no definition beyond, there is actually no definition of an involuntary withdrawal other than that it can occur, but there is no mechanism. So I just wanted to point that out because that is the defendant's strongest argument, to say that the transfer was invalid because of this involuntary withdrawal. They can't then address how that was triggered, but they just come out and say SYV could not have received a valid membership interest because there was no interest for her to transfer because she involuntarily withdrew. They then try to incorporate a buyout option that the company would have then had if there had been an involuntary withdrawal triggered. And therefore, because the transfer happened in that theoretical period, it's therefore invalid. Now, this is a very circular argument because it fails to address what would have ever happened to that membership interest. There's no way that the company has a right to just absorb 100% of the ownership, but that's neither here nor there because it just doesn't add up. What you have is a very clear provision that is much more specific in addressing, and if the court looks at the actual transfer provision that is at 6.1.5, notably the title of that provision is transfers to affiliates and family. Those provisions are, those terms are capitalized and defined. If the court looks at the more general provision of 6.1.2, that provision governs transfers just to a person, and a person is also defined just as any individual corporation, partnership, association, LLC. But the problem is 6.1.5 doesn't govern transfers to persons. It governs transfers to affiliates and family, which are also defined, and which Brandon Ellis qualifies as family of Miss Ellis, and SYV qualifies as his affiliate, who he then transferred it to. So I'd like to point out that since the time that we had our hearing, Your Honor, in June of 19, and as submitted in the affidavit of Ms. Ellis, filed in conjunction with her motion for summary judgment, we've discovered evidence that not only Ms. Brand's attorney, but her own accountant that she uses for her own company, ASC, and that she also insisted on using for the company itself. His name is Tony Adams. He and Kathleen Hart, who represented Ms. Brand prior to Mr. Roslin, agreed that the distribution provision was ongoing and was abided by and was going to meet the tax obligations of the individual members. And I'm going to share my screen. If you bear with me one moment, I would like to show you the specific exhibits that I'm referring to, because they are absolutely outcome determinative if this court decides that there is any ambiguity, because as we know, the court is permitted to consider all attendant and surrounding circumstances to explain any ambiguity. And that case that we cited is Lostico versus Duramo, and that's 238 Georgia Appeals 269. And it was citing OCGA 13-2-2 subparagraph 1. Now, if we look at, this is an exhibit to Ms. Ellis's affidavit. This is an email from Ms. Ellis's former counsel, Joe Delisle, sent to Kathleen Hart, who is Ms. Brand's former counsel, March 7th of 2019. And what Mr. Delisle says is one item, and this is when they were trying to negotiate a buyout, and it never happened, but they wanted to make sure that they crossed their T's and dotted their I's if a buyout did occur either way. And Mr. Delisle said, one item I previously mentioned was to get an agreement about tax distros, referring to the tax distribution. How do we want to handle that? One pager amendment to operating agreement, question mark. And then we scroll up to see Miss Hart's response. Okay, Miss Hart says, Joe, a couple of thoughts. Number one, meaning regarding minimum tax distros, regarding the tax distributions, this is already contemplated in the operating agreement. See the paragraph under section 4.2.2.3. Now, mind you, Your Honor, that provision, that paragraph that Ms. Hart is referring to, that Ms. Brand's own counsel is referring to, is the exact distribution provision that we have cited. It comes just after section 4.2.2.3. And what she says is, to the extent a buyout doesn't happen, I would anticipate this would continue to be done at the end of the year, consistent with past practice. I don't think anything further is needed here. So here you have my client's counsel specifically trying to address what's going to happen for the tax liability. And the defendant's counsel says, we don't need to do anything further because it's already covered and it will continue, quote, consistent with past practice. So that's one email. And we did.
What is this specifically that I'm looking at? I mean, I know it's an email, but is it what it's, okay, I'm seeing up here, it's the affidavit of Sarah Ellis.
Affidavit that was filed June 24th, 2020.
Got it.
And it is, let's see, it's not exhibit 1, I believe it's exhibit 3, but let me just confirm that. Yes, this exhibit 3.
Okay, thank you.
Sure. So that is the email from defendant's own counsel acknowledging that this distribution provision will continue to be in effect if the buyout doesn't occur, okay? Consistent with past practice. Then we have Ms. Ellis, who is formerly known as Sarah Laurie, that was her maiden name. And here is an email to Tony Adams. And she says, she's asking various questions. And here, her question is, with regards to the corporate taxes paid on distribution of profits at the end of the year. And by the way, this is written September 22nd, 2011. This is Exhibit 1 of that same affidavit, Your Honor. So in the beginning, when they're negotiating the operating agreement, Ms. Ellis reaches out to the defendant's accountant, Tony Adams, and says, with regards to the corporate taxes paid on distribution of profits at the end of the year, the corporate taxes on that income would be paid for by the company, correct? He says, no, I know this is confusing. The company profits are passed through to the shareholders based upon their percentage ownership. Each shareholder pays income tax on this income individually based upon their personal income tax rates, whether the profits are distributed or not. That's why, this is the important part. That's why we want to protect you by requiring that 50% of the profits have to be distributed in order that you have the cash to at least pay the tax on this income. So in 2011, you have the defendant's own accountant assuring Ms. Ellis that there will be a minimum distribution of 50% of the profits to cover this tax liability because she will be paying it on her individual tax returns.
Okay, now what is the date of this email?
This email is September 22nd, 2011.
Okay, so that is before the agreement was signed. I have the agreement being signed on September 28th, 2011.
I believe, yes, that is correct.
This is before.
It is before, but it is getting an understanding of.
I asked if it was before.
Yes, it's before.
Okay.
And then when you have the buyout negotiations and Mr. Delisle says, what happens if the buyout doesn't occur? Defendant's counsel says, consistent with past practice, these distributions will continue. So we don't need to have another amendment.
And is there an entirety clause in the September 28th agreement?
I believe there is, but I would have to.
I bet there is. But
yes, yes, but the whole point is that the merger clause that's in the operating agreement, the distribution provision is in there. So we don't need. It's not like we're trying to. What I'm showing the court is the parole evidence that shows the intent of the parties, which this court is entitled to look at under 13-2-2. And the Georgia Court of Appeals has upheld that the court can look at attendant and surrounding circumstances to explain an ambiguity. So this is only, well, we don't think it's ambiguous, but to the extent the court would find an ambiguity, the defendants would certainly argue it's ambiguous because they want it. Well, what they really argue is it's consistent with the other provisions that say the company has the discretion to pay or not pay. Our contention, and what is very clear here, is this phrase right here that says, notwithstanding anything to the contrary, right there, shall be distributed. It's obligatory, shall be distributed. So there is no room for ambiguity in looking at this very specific provision that is sufficient to pay income tax, which is what we're dealing with. And I have cited an abundance of case law in our brief, and I also argued it at the last hearing, that specific provisions govern over general provisions, especially when addressing the issue at hand. And that is the Woody Stakes LLC versus Pastoria case, 261 Georgia Appeals 815 at page 817. And in that case, there were lease provisions that referred to a failure to open for business, and that prevailed over a more general provision referring to a breach of any other covenants, because those provisions had varying cure provisions. And the court said when it's specific, it's going to govern over more general. And what's interesting is that the defendants rely on a case, H.A.&W, Havey, Farragut, and Wynn Financial Advisors versus Johnson. That case is 336 Georgia Appeals 647. And what they want to say is specific provisions don't control over general provisions when they are harmonious. And what's really notable is that that case supports our position, because we've got either the court can say these are completely harmonious because you have this notwithstanding anything to the contrary language, therefore there's no ambiguity, and it's harmonious with other provisions that are more general and that give the majority member the discretion for certain cash flow distributions. But it's harmonious with this provision because it's not governing any and all cash distributions. What this provision is governing is only those mandatory distributions sufficient to pay income tax that's being allocated to the individual members. Now, as a fallback provision, if the court were to deem that these provisions were conflicting in any way, the HA&W Financial Advisors case acknowledges it is true that a specific contract prevails over a conflicting general contract provision. In their case, neither provision prevailed if the two provisions are consistent, and they were dealing with an employment agreement that had an attorney's fees provision in it if there was any dispute. And then there was a promissory note that had an attorney's fees provision for the holder if the holder had to sue to collect on the note. And what the court held is that those were not conflicting. The court found that those two contracts should be deemed an integrated contract, and there was no conflict because you had a specific provision governing the note and you had another specific provision governing attorney's fees for the employment contract. And what ended up being litigated was the employment contract. So the court said, we don't need to fall back on this law that says specific provisions govern over general, because here they're not conflicting. Well, our position is the same, Your Honor. We don't see this as conflicting. If the court were to deem they were conflicting, the court can do two things. The court is obligated to follow the rules of construction, and Georgia law says that the specific provision shall govern. And in addition to that, the court can look at the surrounding circumstances to look at the intent of the parties. And in that case, it's a grand slam because we've got no ambiguity. Then we've got a specific provision that addresses the tax distribution. We have a specific provision that governs transfers to family and affiliates. And then you've got this background information from the accountant and the lawyer saying, don't worry, this is covered. Both of them are saying that, consistent with past practice. So we have not one, not two, but three levels of assurances that these provisions are going to govern. And for those reasons, you've got the distribution that wasn't made. There's no factual dispute over that. They're just going to say that they have the discretion, and they're going to talk in circles, trying to say that this provision has to be read in conjunction with these other much more general provisions. And they're going to ignore this phrase, notwithstanding anything to the contrary. They have to ignore it in order to try to get in their argument. And they're going to say that the other provision governing the transfers somehow is tied in to the 6.1.2 provision here that says that if the conditions of transfer are satisfied, a member, then a member may transfer, but they require consent. Well, that's to any person here, to any person. No person shall become a substituted member without the consent. That's what they're relying on. That's any person. Then they're talking about the conditions of transfer, and their argument is that the written instrument, which is not capitalized, and I'll scroll up to that, the condition of transfer that has to be met here, conditions of transfer on page 4 of the operating agreement. Here, the transferee delivers to the company a written instrument. Notice it is not capitalized. And they will cite to case law that says a written instrument typically is a promissory note or a contract. And that case involved a securities agreement. It had nothing to do with an operating agreement. And if a term is not defined, it's going to be construed in accordance with the general definitions of these terms. And you can't read into this condition that a letter from SYV, which has been presented through Mr. Brandon Ellis's affidavit, informing the company of the transfer. It met all of the requirements of notification, because look, it says the transferee delivers to the company a written instrument agreeing to be bound by the terms of Section 6. That's exactly what the letter said. And they're saying that doesn't satisfy the condition because it's not a signed contract. It's not a promissory note. It's not a initial cap written instrument that is going to meet a definition that is not in this operating agreement anywhere. So that's what they're going to argue. That condition.
Where can I find Mr. Ellis's letter?
I
It's
will
Exhibit B to the amended complaint, Your Honor.
I'm sorry, what did you say, Mr. Biggis?
It's Exhibit B to the amended complaint.
Okay.
There's a transmittal letter from Ms. Ellis's previous counsel, and attached to it are the two joinder agreements.
Okay, thank you.
Your Honor, do you want me to pull that up?
No, go ahead. I got it.
Okay. So the conditions of transfer were in fact met, and he was family, and then he transferred it to an affiliate. So that's met. So there's really nothing for them to rest on to say that the conditions weren't met, or that Section 6.1.2 is going to govern when that provision is governing transfers to any person. And then 6.1.5 is much more specific because it is transfers to affiliates and family. And again, you have notwithstanding anything set forth in this agreement to the contrary. You've got nothing in here providing discretion for ASC as majority member. Notwithstanding anything set forth in this agreement to the contrary, provided that the conditions of transfer are met, any member may at any time, from time to time, transfer all or any portion of any interest to any other member, any member of the member's family, or any affiliate of the member. There you have it. And that's notwithstanding anything else in the agreement, meaning the discretion to accept or reject the transfer to any other person. If the parties wanted to give that discretion for any transfers whatsoever, there would have been no reason to include Section 6.1.5. Likewise, if the parties, and I'm gonna take the sharing off because I think I've pointed out the provisions enough, but the same argument applies to the distribution provision, because there wouldn't have been a reason to include that language. And I cited in our injunction hearing, this is a very helpful case, the State of Pitts versus City of Atlanta. It's 323 Georgia Appeals 70.
I'm sorry, State of who? I didn't hear that.
State of Pitts, Pitts, versus City of Atlanta, and it's 323 Georgia Appeals 70. It's a 2013 case. And the Court of Appeals held that the construction which will uphold a contract in whole and in every part is to be preferred. That is citing OCGA 13-2-2 subparagraph 4. And the Georgia Supreme Court had vacated the judgment and remanded, finding that the phrase involved in the project, which was at issue in that case, would be redundant if not intended to serve a limiting purpose. The court said there was no reason to include that provision if it would be redundant. Here, you've got the distribution provision specifically tailored only to meet the tax liability being assessed to the members. There would be no reason to parse that out and say notwithstanding anything to the contrary, if the intention of the parties had been to give ASC as majority member absolute unfettered discretion over any and all distributions, no matter what. If that had been the goal, they would have stopped short of adding that provision. Likewise, if the parties had intended to give ASC as majority member the discretion to accept or flatly reject a transfer by Miss Ellis to anyone on the planet, they would have stopped at 6.1.2. There would be no reason whatsoever to include 6.1.5. And the Court of Appeals has repeatedly held that you have to uphold every provision of a contract where possible. They've again and again said that these specific provisions, both of which these are, will govern over the more general provisions, and that the court should avoid an interpretation of a contract which renders portions of the language of the contract meaningless. That was the case of Holloman versus D.R. Horton, 241 Georgia Appeals 141. In that case, the court held that there was an addendum to a home warranty that would be rendered meaningless if it weren't given the meaning being advocated by the home buyer in that case. Now, the case of Estate of Sam Farkas versus Clark, 238 Georgia Appeals 115, on page 120 of that case, the court also said, looking at a provision for possession at closing, and it was subject to a lease that was attached to that property, and any rent was subject to proration. There was a disagreement over the possession not being given because the tenant refused to vacate. And the court said, you have to look at that provision, because if you don't, the terms would be rendered meaningless. There would have been no reason for them to add in the right to make it subject to that lease. The case Insurance Company in Pennsylvania versus APAC Southeast, 297 Georgia Appeals 553, also applied the rule that a contract should be construed in a manner that gives effect to all of the contractual terms. And the court specifically said the parties would not have included two terms in short sequence of each other in a contract if they were intended to mean the same thing. Your Honor, this is very important, because if the court were to enforce or allow ASC as majority member to exert discretion over all distributions, it would render null and void the much more specific provisions, both of which say, notwithstanding anything to the contrary, this is our intent. We intend for the distribution to occur to cover this tax liability. It even says this is specifically to be in the minimum amount of the maximum tax bracket. It's very specific, Your Honor. Likewise, the transfer provision of 6.1.5 is specifically tailored to affiliates and family members in a way that is not at all addressed in 6.1.2. So to rule otherwise and to allow discretion to infiltrate these provisions that don't provide for discretion, to the contrary, they say, notwithstanding anything else that has been said in this entire agreement, we are allowing these things to happen. We're mandating the distribution, and we are allowing these specific transfers just to family and affiliates without any discretion required, without any vote required, because otherwise, Your Honor, to rule otherwise would fly in the face of all of these cases that I just cited. And in the State of Pitt's case, 323 Georgia Appeals at page 79, the court said the cardinal rule of contract construction is to ascertain the intention of the parties, and every other rule is subservient to this one. Your Honor, plaintiffs contend that not only is the language unambiguous, but these provisions are both very specifically tailored to the exact issues at hand, both with respect to the distribution that is required and with respect to the transfer that occurred to Mr. Ellis and subsequently to SYV. We also have, again, which this court is allowed to look at, Tony Adams' representation to Ms. Ellis. Don't worry, we're going to make sure this that a distribution of profits is made to cover your tax liability. And then all the way in 2019, you have Ms. Hart assuring plaintiff's counsel that no amendment is needed because it's already covered in the operating agreement as it exists, that the distribution of it provision will continue to be in effect, consistent, quote, consistent with past practice. So for those reasons, we believe that we are absolutely entitled to summary judgment on the issue of the distribution and on the issue of SYV being deemed a member because the transfer was valid. It was permitted to a family member and to an affiliate, and the conditions of transfer were clearly met. And there is no way that the court, that defendants can inject a case dealing with a security agreement where the court said, typically you'll see a note or a contract that has nothing to do with this situation or an operating agreement. And they're not going to be able to cite case law to the contrary, Your Honor. And with that, I will reserve some time for rebuttal.
Okay, before you, just a couple of questions. Do you contend that SYV is still a member of American Lighting Control?
Yes, Your Honor, 48%.
Okay, all right. And I guess the question also is from the plaintiff's perspective, is American Lighting Control still operational?
My understanding is that it is.
Okay. All right. Thank you.
Thank you, Your Honor.
All right, Mr. Riggerish.
Your Honor, there are really 2 points with this, and I can address them in the order you prefer, though I can address, I think, as cleanly as I can, the issue of SYV's status first. And because the distribution issue is somewhat separate from that, though our position on the distribution issue, and this runs from, curiously, Ms. Ellis's affidavit and the exhibits attached to it, which is that the past practice under the operating agreement does not conform to what Ms. Deutschman has argued. But let's talk first about the question of SYV's status. And that's significant because if SYV is an assignee or other economic interest holder, it has no rights to what it's already been received on a discovery order, but has no right to access to books and records. And arguably, under one provision of the agreement, would have no right to a distribution, which is a secondary argument for us. But let's start with where Ms. Deutschman sort of ended. And that's with the first mechanism by which SYV, the assignment of interest to SYV fell short of transferring a membership interest. And that's the language in the operating agreement that starts at section 6.1 and continues through through section 6.5, which is the transfers to affiliates and family members, which Ms. Deutschman has cited. 6.1.1, again, it's all Article 6, describes conditions of transfer, which is a reference back to a defined term in the agreement. And one of the conditions of transfer, and we'll talk about others as well, but one of the conditions of transfer, and this is at page 4 of the operating agreement under Article 1, which is the defined terms, it defines condition of transfer at B, which is that the transferee, which in this case would be Miss Ellis's husband, Brandon, and then from him to SYV, the transferee delivers to the company a written instrument agreeing to be bound by the terms of section 6 of this agreement. If we then look at Exhibit B to the amended complaint, which are the 2 joinder agreements, which plaintiff tenders as constituting those transfers that satisfy the conditions, they don't say that. They say something very different. And if we look at Exhibit B which is to the original complaint as well as to the amended complaint. It states, does not have a signature block for ASC or the other member of the entity, but it states that the undersigned is executing and delivering this joinder agreement.
I'm sorry, the undersigned is what?
The undersigned is executing and delivering
Executing.
this joinder agreement by executing, and then it goes on to a second paragraph, by executing and delivering this joinder, the undersigned agrees to become a party to and be bound by and to comply with the provisions and the membership rights and interests held to the agreement, as if the undersigned was an original signatory to this agreement. That is not the language in conditions of transfer B. The second point, and this goes to defined terms versus ones that aren't, is what is a written instrument? Again, that is not a defined term in the agreement. A written instrument, as we explained, and in case law we cited, including the statutory language in our brief and response, is a written instrument is a thing like a deed where two parties sign a document. That was not done here, and that ties directly to another provision in the 6.1 transfer provision, which is,
I'm sorry, did you say deed?
for example, a deed, yes, or a contract or agreement.
Signed by the grantor, isn't it?
Well, it's often signed by the grantor and the grantee. It's a written instrument. If you look at, we cited the case, I can give you the site, Your Honor, if you like, and the statute which describes what constitutes a written instrument, and that's not here. But the key other point with that is if we look at paragraph 6.1.2 of the operating agreement, it states it subjects the transfer to a requirement of the consent of members holding majority of the membership interest, which is ASC. Consent was neither sought nor granted. So we've got a consent provision in here as well. So on the
Tell me where, I'm so sorry. Tell me where the consent provision.
6.1.2 on page 23 of the operating agreement. It's the first sentence.
Okay. Okay.
And again, this goes to the distinction between SYV being a member as opposed to an economic interest holder. So we've got two elements here. We've got the express condition of transfer, which defines what you say in the written instrument, which was not said in the joinder agreements. And second, you've got 6.1.2 saying you don't become a member unless you get the consent of the majority member. Businesses are run, partners get to decide who their partners are going to be. And that's what this situation is. So the consent was neither requested nor given. And the condition as it's described in the defined terms of the agreement wasn't satisfied by the two joinder agreements. So that's the first part of that. And the consequence of that is then stated down at 6.1.3. I'm sorry, later in 6.1.2, that what you would have rights to only to become an interest holder with a right to allocations and distributions. So that if not a member under 6.1.2, then that's all you can get. But then if you look at 6.1.3, that if a transfer is made in violation of the prohibition contained in section 6.1, i.e. without consent, it's invalid, null and void. And one of the consequences of that is there's no right in the transferee to receive distributions. There are alternative ways in this case, Your Honor, to get to the point that's key here, which is that SYV is not a member and has no right to a distribution. This is one of those. A second way, which was referenced by Ms. Deutschman, is the involuntary withdrawal provision. An involuntary withdrawal occurs, and it's defined in the contract. With involuntary withdrawal is again defined in the defined terms of the agreement, and it's occasioned. And the specific provision is on page 6 of the agreement. It's Roman numeral 14. If the member or any of its affiliates commits any act or admits to commit any act constituting cause. And then if you look at cause, it includes breach of the operating agreement as well as breach of fiduciary duties and other terms. If we then look at what happens when you have an involuntary withdrawal, we look forward in the agreement again to section 6.3.1 through 6.3.1.5, which is at pages 24 and 25. And we have highlighted, a highlighted copy of this was attached with our pleading, but we've got, I know there are several versions of this operating agreement. I'm not sure which one you're looking at. But if you look at that, Ms. Deutschman argued that, oh, well, you really don't have a mechanism for establishing this. You have a very explicit mechanism for establishing what an involuntary withdrawal is. If Ms. Ellis does something that constitutes cause, it's deemed, paragraph 6.3.1, an offer for sale, a withdrawal offer. And the consequence of that, I mean, it's deemed, you know, it's not something that requires notice unless ASC is going to exercise its option to buy. It happens if there's cause. And then if that cause occurs and ASC decides not to make an offer to buy the interest, you go down to 6.3.5. If the withdrawal offer is not made or not accepted upon the expiration of the withdrawal offer period, which in this case is 60 days at latest after May 31st when Ms. Ellis left, then the previous member or her assignee is an unadmitted assignee of the member. And that's the alternative way that we get to the point that SYV is not a member. And it's because there was cause. And there are undisputed facts establishing that the cause definition is met. There's certainly a lot of disputed ones as well.
Well, then let me just ask you this. Was the K-1 sent earlier this year for all of 2019 or for just through June of 2019?
The dollar amount, I believe, was for the remainder, from June through December of 2019. And it was sent to SYV as an economic interest holder.
Then maybe I'm misunderstanding.
Well, understand, Miss Ellis had already paid. Miss Ellis had already paid taxes. We think she's paid taxes. There was a distribution made, and we'll talk about how these monies were used by the members in the past. But my recollection is that the K-1 was issued in 3 parts, basically. One to ASC, one to SYV, and one to Miss Ellis, which is not it. The one to Miss Ellis is not at issue.
Okay, so I thought maybe I misunderstood your argument. I thought your argument under 6.3.5 was in absence of anything, then Ms. Brand owns everything.
No, that's not the case.
Okay.
We only get to that point. The only way that happens is, and it's an alternative again, which we don't have to resolve for purposes of the motions before the court, which is under 6.1.3. Yes, if you have a failure of satisfying the conditions of transfer, including the consent, then if you read 6.1.3, there's no right to receive distributions. But we don't have to get there, Your Honor. And I'll address that when I talk about the distribution issue.
So was your argument then under 6.3.5 that the plaintiff is an interest holder?
Well, it's an unadmitted assignee of a member under 635, which is the same thing effectively. They use different language in the two different provisions. Is the same thing as is an interest holder in 6.1.2.
Because am I right in assuming that because your client sent a K-1 for the latter part of 2019, then your client has admitted that there's something?
That we treated SYV as an unadmitted assignee, whether you call it, and the K-1 doesn't call for you to define this. It was an economic interest holder, which is a tax term as I understand it. So we treated SYV as an economic interest holder. Whether you get there as an unadmitted assignee under 6.3.5, or as a economic interest holder under 6.1.2. Either way, SYV is not a member.
And only members, your argument then is only members get enough money to pay their taxes?
No, that's a different point.
Okay.
The member status in this case is most significant for purposes of the right to books and records, which again, that's sort of overcome by events because as a discovery matter, the court allowed access to that. And Ms. Gould, the plaintiff's accountant, came in and made copies of everything, which we'll want back at some point, but that's neither here nor there. So to some extent, at least to this point, that's been overcome by events, but it's important for us for another reason that SYV is for continued operations, which is the point of our declaratory judgment motion, that we know what SYV is. And SYV is an unadmitted assignee or an economic interest holder and not a member. And you get there a couple different ways. One is through the failure to meet the conditions of transfer and obtain consent under 6.1.2. The other is through the cause event resulting in an involuntary withdrawal. And the cause event in this case is established by multiple things, some of which are in dispute. One very specific one is not. In the letter attached to the original complaint and the amended complaint from plaintiff's previous counsel, Mr. Delisle, the one that transferred those joinder agreements we were looking at. Again, it's Exhibit B to the original complaint and the amended complaint. Mr. Delisle stated, and this has been confirmed with our review of computers, which is another issue a little further down the line, that Ms. Ellis, in violation of the operating agreement's provision, maintaining the confidentiality of records at 210.1, made copies of everything that were on our computer, then erased the computer or imposed passwords on it that made access to it difficult. But she deleted stuff from the computer. She erased one completely. The second one she imaged twice, making copies of what was on her computer. And
I object, Your Honor, because this is not in evidence at all.
Yes, it is. Yes, it is. It's the affidavits that have been filed, the most recent from Mr. Barlow on Monday, along with the affidavit, the second supplemental affidavit from Ms. Brand.
You referred to Mr. Delisle's letter, so.
No, Mr. Delisle's letter is Exhibit B to your complaint, counsel.
Right.
Exhibit B to your complaint is Mr. Delisle's letter, where he says what there's no dispute happened, which is that Ms. Ellis made copies of our records. And 210.1 of the operating agreement says those records belong to us. The last sentence of it, again, we're looking at page 10 of the operating agreement. Upon termination of a member's membership in the company, which occurred with her resignation and transfer of her interests, all property belonging to the company, meaning ALC, including without limitation all confidential information, physical embodiments and copies thereof, give them to the company. She didn't do that. Mr. Delisle's letter admits that she kept them. And we know from later issues we have in this case, which is the attempts to recover ALC's website, that we can't recover that website without getting back from her what she copied and what Mr. Delisle described in the letter. So,
is this an argument, Mr. Rigorish, that she had involuntarily withdrawn for cause reasons?
it is one way in which we have cause, which starts the involuntary withdrawal provision. It's deemed an involuntary withdrawal when she committed cause. And the cause occurred when she did that at the end of May 2019 at latest. Now, there are earlier events, which the evidence on the website has disclosed, that she did a lot of things before that were in breach of the operating agreement, registering the website on her private email address, for example. But the one that is cleanest for purposes of establishing cause is that she took the records in violation of 210-1, the last sentence of 210-1 specifically. So again, our point is that SYV is not a member under either of two mechanisms. The first of which is they didn't satisfy the conditions of transfer. The joinder agreements don't satisfy, they don't comply with the language of condition of transfer B. And second, and he didn't receive consent under the 6.1.2 provision that we've walked through. And alternatively, that there was cause which was deemed an involuntary withdrawal, which gave ASC a 60-day period to decide whether or not it wanted to pay Ms. Ellis for her interest, which under the circumstances it had no interest in doing. And at the conclusion of that 60-day period, you have a 6.3.5 event, which is that her assignee is an unadmitted assignee and not a member. Her assignee ultimately through her husband, SYV. So there are two ways we get to that point. Now, Your Honor, I'd like to, if I made that as clear as I can, I would, and I know it's not the easiest thing to go through. And again, there are there's other cause in the record before you to establish an involuntary withdrawal, but that's the cleanest one we can work with. I'll move on to the distribution issue, if I may. The distribution issue, let's talk about what the contract construction principle is. And that is described in a couple of the cases we've cited, GAP 3 and the H&W Financial Advisors case, which Ms. Deutschman referenced. And they talk about, as does the estate of Pitt's case, it's consistent with the OCGA 13.2-2 provision, which is you uphold a contract in the whole and every part is to be preferred. And what it calls for is you look at all the provisions of the contract and you look to harmonize them. Although Ms. Deutschman doesn't refer to it this way, what she's really arguing is that the later, she describes it, specific provision trumps the other provisions. You don't look at those. And it's our position, Your Honor, that if you read the contract as a whole, and this goes to our motion for declaratory judgment, if you read the contract as a whole and you look at the distribution, and this is consistent with the past practice as established by exhibits to Ms. Ellis's affidavit, which I'll talk about in just a moment, you have to read the provision that Ms. Deutschman relies upon on the distribution, which again is that provision that follows 4223 on page 15, which talks about distributions from cash flow. You have to read that in the context of cash flow, which is paragraph 4.1.3 on page 14. 4.1.3 states that it shall be distributed in proportion to their percentages as determined by the majority of the members, which by other terms we know means ASC, in their sole discretion, which may be exercised arbitrarily. That's a broad discretion provision that vested in ASC the decision-making on making distributions. You have to read the paragraph added after 4223 in the context of 4.1.3. And you can't harmonize those, which is ASC has the discretion and it's giving some guidance about how the company would consider making distributions. What's interesting here, Your Honor, and we're going back to the same exhibit to Ms. Ellis's affidavit, her June 24th affidavit that Ms. Deutschman referenced. If we go back to that at different pages, we see a couple of things, and I'll walk through a couple of things about the operating agreement that I think we need to clear up first. The operating agreement was executed with an effective date of September 28th, but the affidavits, including some emails talking about terms that were referenced by Ms. Brand's affidavit, emails from Ms. Ellis, show that the contract, the operating agreement, wasn't signed until December. They had an effective date that went back 3 months. The Tony Adams email they're talking about was before even that, in earlier in September of 2011. And it describes one possible way. It talks about two alternatives. One, Miss Ellis being an employee as opposed to being a member. And he walks through tax consequences, which is that this will be a pass-through entity and your share in profits would be passed through to you. And then he talks about a 50% guarantee. There's no 50% guarantee that appears in the operating agreement when it's signed 3 months later. What instead appears are these provisions. The discretion in ASC as the majority member to make distributions, and then this language talking about making distributions sufficient to pay taxes. Well, they did make distributions sufficient to pay taxes. And if we look at Ms. Ellis's affidavit, again, the June 24th affidavit, at the same exhibit 3, I'm sorry, yeah, I believe exhibit 2, I believe, I'm sorry. Exhibit 1 was the Tony Adams email from September 22nd, 2011 that Ms. Deutschman covered with you, where it talked about a pass-through entity and the anticipation that there would be a 50% of profits distribution. There was no 50% of profits distribution language included in the operating agreement when they ultimately signed it in December. If we look further into Exhibit 2, you will see about 6 or 8 pages into it, a weekly meeting agenda, which was prepared by Sarah Ellis. The first page of that is one that describes action items, and it talks, and this was an agenda from Sunday, December 17th, 2017, Your Honor, if and when you have a chance to delve into that exhibit. I know it's buried in there. If you look at that, you'll see they're talking about distributions. And Ms. Ellis talks about doing a 100,000, she describes it as tax distribution, with 52 to you, meaning ASC or Ms. Brandt, and 48 to me. And then she says, 44K of that will go on my 401k instead of me. It's not a tax distribution, it's a distribution, and she's making choices about how she's going to use the money. If you look further into that Exhibit 3, to another, the third page after that one, and it has again the time 2 to 2:30. It looks like it's the third page of this action items for this meeting on December 17th. You look at the last item on it. She says, I recommend a $100,000 distribution. This is Miss Ellis. She's recommending. She's not saying, oh, the operating agreement requires that we make a distribution of this. She's making a recommendation, and that is consistent with the other language in the operating agreement, which talks about distributions for cash flow being made by ASC. Again, we're going back to the provision on distributions. At paragraph 4-1-3 on page 14, which says distributions are determined by the majority of the members, which again is ASC, the 52% owner, in their sole discretion, which may be exercised arbitrarily. So if we go back and look at past practice, and if we look at these emails, you have the first thing, Tony Adams is talking to Miss Ellis before they've reached an agreement about here's the different ways we can do this. One of them will be a pass-through. And it's anticipated there'll be distributions, so you'll pay your taxes from it. That language doesn't appear in the operating agreement. The next thing we have is Miss Ellis's own agenda items saying she's recommending and using money from this distribution that she calls a tax distribution being issued before we even know what the taxes are going to be at the end of the calendar year instead of when the taxes have been prepared in February or March by Tony Adams. And she's recommending a distribution of which she's going to use it for a 401k instead of paying her taxes with it. She's certainly able to do that. She has that choice. But the point is it's recommended and it's a discretionary decision with ASC from the cash flow. That's what it is. At a minimum, there's a genuine issue of material fact from Ms. Ellis's own words that would prohibit them from enforcing this supposed distribution provision because it's not consistent with the operating agreement.
Well, that's what I was going to ask. So how is this discretionary distribution inconsistent with the operating agreement?
No, the discretionary distribution by ASC is absolutely consistent with the operating agreement. They're not obliged to make distributions. They exercise business judgment on that. And that's what ASC has done in the past, as indicated by Ms. Ellis saying, I'm recommending a $100,000 distribution.
And you're saying that the distribution that was evidenced in the 2019 K1 was similarly discretionary. Again, the K1 just allocated the profit. It didn't make a distribution. K1s record allocations of profit. If a company decides to make a distribution, it exercises business judgment to do so. And again, our situation in 2020 is very different. We have COVID. We have Ms. Ellis having left and wreaked some havoc from our position. I understand Ms. Deutschman disagrees with that, with the company. And the company having to bring in the company, meaning ALC, to the extent it decides to continue to operate as ALC, having to bring in Ms. Brand to manage it. And they exercised that discretion not to make a distribution, even though there's tax liability. There was no distribution made to ASC in 2019, and there was none made to SYP as a economic interest holder. Because again, we're in COVID, and we're dealing with the repercussions left by Ms. Ellis having left. And they exercise that broad discretion, absolute discretion, not to make a distribution. That happens in business. Let me make sure I was with you, believe it or not, up until this last thing about the December 2017 agenda item.
Yes.
Are you suggesting that the discretionary, all right, 4.2.2.3 on page 15.
Yes.
States that the interest holders, distributions are to be made for the purposes of allowing the interest holders to have cash sufficient to pay income tax. So this provision, which the plaintiffs say is absolute and should be enforced, somehow you're telling me that the December, the 2017 agenda, we should do this a different way.
The only point
I'm
with,
lost as to what this means.
yes, the only reason that the agenda item that Ms. Ellis attached to her affidavit is significant is because it indicates that that distribution of an amount sufficient to pay taxes wasn't mandatory. It's discretionary. She's making a recommendation. And you don't make a recommendation if the operating agreement says we make an automatic distribution. The operating agreement doesn't say we make an automatic distribution.
And what provision of the operating agreement are you, and you mentioned it, and I have it here somewhere, but you mentioned that some provision of the operating agreement, perhaps on page 14, or just tell me, makes the distribution discretionary and not mandatory.
On page 14, 4.1.3.
4.1.3. Okay, thank you.
And I'll just make a reference to another provision that acknowledges that discretion. And that's on page 19 at 5.1.2, which talks about the things the manager can't do. And if you look on page 19 at 5.1.2, and in particular 5.1.2.4, it says extraordinary transaction requiring the majority member, meaning ASC approval, includes making any distribution of cash flow. So if in our point, Your Honor, is you can't read that distribution language after 4223 without looking at it in the context of 4.13, and as just another example, this 5.1.24, which talk about who has the discretion to make those judgments. And businesses, that's the way businesses work. You don't make distributions if you make a business judgment that you need to keep the money in the business. Fortunately, during Miss Ellis's tenure there, they were doing well. They had money coming in. They didn't have COVID-19. So they made distributions of around $100,000 at the end of the year, which the two members at that time, Miss Ellis and ASC, could use as they wish, including paying the taxes for 4 months later in April, when their personal taxes became due.
Let me ask you one question, Mr. Rigorich. Smoke may start coming out in a minute, but you want a declaratory judgment that SYV is not a member.
Yes.
You also want either summary judgment or declaratory judgment or some pronouncement by this court that plaintiff, and I don't know if that's plural or not, but plaintiff was entitled to an additional, the plaintiff was not entitled to an additional distribution to cover the taxes because decisions made by members could have been discretionary.
Our position, Your Honor, and this goes for purpose of a declaratory.
SYV, though, was not making any decisions.
That's correct, Your Honor.
Okay.
And the point is, and it's a declaratory judgment issue because we're still dealing with SYV. SYV is still an economic interest holder or unadmitted assignee, depending on whether it was an involuntary withdrawal or a transfer without meeting the conditions of transfer plus getting consent. But we're still dealing with an entity called SYV. And what we're asking a declaratory judgment is, it has the effect of addressing the point you just raised, but is how do we deal going forward with SYV on the question of distributions? The declaratory judgment issue calls for construction of the agreement as a whole, harmonizing the multiple provisions so that none of them are rendered meaningless and that they're construed in harmony, And our position is the construction of the operating agreement contract on the distribution issue has to harmonize this language that was added after 4223 with the language in 4.1.3 and the ancillary one at 5.1.2.4, which is that ASC has the discretion to make those judgments. And it's our position that the proper contract construction, reading the agreement as a whole, you can and should harmonize those provisions to say, yeah, we're getting guidance on how we want to do distributions, but the discretion is still with ASC, and that discretion is absolute. So while you allocate, as businesses do, I mean, sometimes business owners have to bite the bullet and pay the taxes, even if they need to keep the money in the business. And that's the position we're in, we believe, right now. And again, that's a business judgment for ASC, which is managing the business, which is with the COVID situation, with circumstances that they are, which include the harm done to ALC by Miss Ellis as she went out the door. We need to keep the money in the business. And that's what we've been doing.
Okay, so you want a declaratory judgment that SYV is not a member. I'm not sure what status you want me to declare them as, but let's say unadmitted assignee, they're still entitled to something.
Well, they at this point, if assuming we don't go, and I don't think we have to go to 6.1.3, which is a failed transfer, says you don't get any distributions at all. And I'll acknowledge, Your Honor, our issue in the K1 indicates we didn't go to 6.1.3. We didn't say you're not getting the distribution. Okay. We've treated it as an unadmitted assignee or economic interest holder.
Okay, and you further want me to find or declare that as of June 2019, the only person entitled to make any decisions was Ms. Brand?
No, Your Honor. What we would do is ask the court for a declaration harmonizing the two provisions, the provision after 4223 about distributions with the cash flow provision 4.1.3, which is that the managing member of ALC, which is now ASC, has the discretion to make or not make distributions.
Okay, so what I just said, substituting the name Ms. Brand for ASC, you want me to find that as of June 2019 or whatever date, is that the defendants were the only ones allowed to make decisions?
Well, they were always, our point is ASC was always the one to make distribution decisions and did. That's the point of Miss Ellis's affidavit exhibit, saying she's recommending a $100,000 end of year distribution at the end of 17. She's making a recommendation because the operating agreement doesn't mandate it. And that recommendation was accepted in 2017. And it wasn't, and Ms. Ellis chose not to use the distribution for taxes. She made a 401k contribution. She covered her taxes other ways, which is all fine. But that's the point, the second point of our motion for declaratory relief. A third point goes to another provision in the agreement. And this one is only necessary because of the claims that have been raised by plaintiffs. And that goes to the question of, does ASC even need to operate ALC at all? Because it had the option under paragraph 2.9a of the agreement. And this was a very specific term, and Ms. Brand's affidavit describes the negotiations of this issue back in 2011. And that's where we learned when the agreement was actually executed. But if you look at 2.9a at the top of page 10, it starts on page 9 and goes on to page 10. In the interest of clarity, the remainder of that paragraph goes to describe that ASC can do what ALC is doing. ASC is basically a device that was created to give Miss Ellis the opportunity to participate in profits. That's the way it was operated. This provision provides that the minute she walks out the door, ASC could have chosen to shut ALC down, not use that entity at all, and continue to do the commercial business that it did as ALC did, operating as ASC's commercial division with other commercial accounts. And this goes back to what ASC was doing while Miss Ellis was there and what it can do going forward, which is why it's a declaratory judgment issue, which is ASC can shut down ALC tomorrow under 2.9A and just—
Mr. Regish, would you say that again?
Yes, under 2.9A, ASC, since Miss Ellis had left as of May 31st last year, they could shut down this facade of ALC and just fold the ASC commercial business into ASC. ASC was doing commercial business while ALC was created, and it continues to do so today. And this provision, which is we're seeking a declaratory judgment on as well, because it governs how we go forward, it allows us to basically—
Why is that my business? Why is that not a defendant cross-claim business?
Well, it's a declaratory judgment issue because it's this provision and we need declaratory guidance so we can go forward.
Well, is there a cross-claim? What do the plaintiffs care?
Plaintiff cares a lot, because if we choose to do that, SYV's interest, whether as an economic interest holder or assignee, disappears. They'll own 48% of nothing. And we're going forward. We need to decide whether we have to continue this facade of ALC, which was designed solely to pay Miss Ellis, or can we go ahead and shut it down and fold the business over so that we're not again faced with the other issue we've got here, which is distributions. If we shut down what this commercial division ALC operating as ASC, then ALC disappears. This provision gives us the right to do that, and we don't have to deal with the distribution issues with SYV going forward. It's 48% of— if there's zero distribution, if there's zero revenue, there's no question about SYV being allocated profit and having a tax obligation. So if you grant the declaratory judgment, and again, the point of declaratory judgment is how we operate going forward, you're blessing, giving the court blessing of 2.9A, saying, yeah, you can shut it down. And that does away in the future with the kind of distribution issues that we're all struggling with now. That's why we're seeking declaratory judgment on that and believe it's appropriate.
Okay.
So Your Honor, in going through the operating agreement, I've addressed our declaratory judgment issues. And the effect of the declaratory judgment issues, Your Honor, just so we're clear on this, which govern our operations going forward, which is what a declaratory judgment does, is it resolves the claims of SYV against defendants. If it's not a member, and if ASC has the discretion to make or not make distributions, and it has the discretion under 2.9A to basically fold the tent on ALC and operate the ASC commercial division as a part of ASC, then we're resolving all the issues associated with SYV going forward. Coincidentally, when you decide the declaratory judgment on 2.9A, which is a contract construction issue, that also addresses claims made by Miss Ellis against Miss Brand and ASC, particularly a claim that, first of all, there are really a couple of them, the claim that ASC owed fiduciary duties to Miss Ellis. It didn't. It was a majority member, but it was not the managing member, which in the key case that both Ms. Deutschman and I've cited, the ULQ case, it's clear that where that fiduciary duty arises is when you're managing the ALC. And that was what Miss Ellis was doing at the time. And that's the basis of counterclaims that we have against them. But effectively, Your Honor, the declaratory judgment resolves the claims made by SYV against our clients, including a conversion claim, which would also be dismissed anyway, because you don't convert money. A conversion claim goes to property, not to money. And they're claiming that the failure to make a distribution was a conversion. And it's not. It's at most a contract issue, and our position on the contract is, again, ASC had the absolute discretion to make or not make it. But that's not the basis for a conversion claim. There's also no right by an LLC member or an interest holder to get an accounting. So the claims, if our declaratory judgment is granted, as we've proposed it, and plaintiff's motions for partial summary judgment are denied, which it must be even if you don't grant declaratory judgment, because of this history of behavior and the circumstances which show that the parties didn't, as Ms. Deutschman has argued, and a lawyer looking at the agreement 8 years after the fact looks at it and says, hey, it looks like you've got a distribution term already addressed here. If we go to that provision, which was the lawyer in March of last year, where Joe Delisle came and said, hey, we need to look at doing a tax distribution. He read the agreement and didn't think that it mandated a tax distribution. The lawyers were talking. We don't decide cases based on lawyers talking, trying to work out a buyout deal, which was the context of that first provision cited in the Ellis affidavit, which were the lawyers' exchanges in March of 2019. That doesn't demonstrate that plaintiff wins summary judgment. It demonstrates, again, that if you get past the construction of the agreement, applying contract construction principles, that we're going to have a jury issue on that. We don't think there is one, because we think if you construe the contract, the operating agreement consistently between ASC having the discretion to make distributions, and construe that provision with the one about talking about making distributions so you have enough money to pay your taxes. If you read those together, the contract's clear. The discretion is still there. And when you have that discretion, you don't have a right to a distribution.
Thank you.
Thank you.
All right, Ms. Dutchman, that's a lot to respond to, but I'll give you an opportunity to do so.
I greatly appreciate that, Your Honor. I would like to go back to sharing my screen if I can for a minute.
Excuse me, Judge, can I get a quick comfort?
Yeah, our court reporter's been going for an hour and a half now, so let's all take a 10-minute break, okay? Thank you.
Thank you.
That's what she's watching. And the payments after.
Transfer. Let's see, transfer.
Okay, Samantha, tell me when you're ready to come back.
I'm ready, Judge.
Okay, that was a good idea, Samantha.
That's a
All
great
right.
idea.
We're back on the record, and Ms. Dutchman, would you like to proceed?
Yes, thank you. Okay, so I took that time to try to organize the arguments that were addressed, and it sounded like Mr. Rigorish kind of jumped into some of the summary judgment arguments on his side as well. Well, that's my timer to come back. I think I'll just try to work a little bit of that in as just to rebut what he argued. But first off, this is the first time that Mr. Rigorish has announced that they are completely retracting from their position that SYV has nothing at all, not even an economic interest. So that's good. We've always contended that the issuance of the K-1 admits that the company saw SYV at a minimum as an economic interest holder, and they treated SYV as such. And because he has now admitted that they did not operate under 6.1.3, which would declare the transfer null and void, nor can they now try to backtrack and say there was an involuntary withdrawal, because under 6.3.1, they argued previously, there was a buyout period and the transfer occurred in that buyout period, and therefore it was null and void. So they've kind of shot themselves in the foot by issuing that K-1, and they can't go back and trigger either of those. So that's the K-1 issue. The fact that the distribution provision should be discretionary is just preposterous. When you look at Tony Adams' email, it doesn't matter if it preceded that operating agreement by 6 months or 2 months or a year. The understanding by the company's own accountant was that there would be a provision to cover the tax liability. He was explaining that the taxes get passed through to the individual members and they pay their own taxes. They are responsible for those taxes to cover the profits allocated on the K-1. Whether it ended up being a 50% minimum distribution or any other profit distribution, the understanding back in 2011 was that it would be covered by a distribution, and that was reiterated. And it's disingenuous to say it was just two lawyers talking. As I indicated on the exhibit that I showed, this was a specific question by Mr. Delisle. If the buyout doesn't occur, what happens with the tax distributions? We need to cover that. And Ms. Hart's response was, we don't need to cover that. It's already covered in the operating agreement. Consistent with past practices is how she put it. It will continue. That's not just two lawyers talking. That's an admission on behalf of defendants. So that's that. The cause that Mr. Roslin would like to contend is undisputed. In looking at Mr. Delisle's letter, I'm going to share my screen, if I may, Your Honor, and go back to that letter. First of all, the copies that were taken, he said, hold on, let me just get to it. Complaint. Exhibits. Here, this is Mr. Delisle's letter that is attached as, here we have Exhibit B to the complaint, and it's Exhibit B to the amended complaint as well. June 7th, 2019, Mr. Delisle writes to Mr. Roslin and says, for the historical materials of ALC that predated the transfers and Ms. Ellis's resignation, SYV can simply take possession of copies of certain hard copy materials and electronic files that are currently maintained and possessed by RICO, the third-party vendor with whom Ms. Ellis deposited such materials upon her resignation. That's what was said. She retained those materials, put them in storage. They were just copies, and they believed, because the transfer was valid, that SYV would then take over possession of those copies. So it is not any violation of Ms. Ellis in maintaining those copies to transfer along with the membership interest that validly transferred to SYV. The argument that these provisions need to be harmonized and that one doesn't trump the other really, and I already argued this, but I want to really reiterate this. Both of these provisions say notwithstanding anything to the contrary. That phrase is crucial because it means we don't intend to conflict with those other provisions. We intend to create a carve out for tax distributions and a carve out for transfers that are not to just any person. They are transfers to a family member or an affiliate. So the affidavit that was just submitted by this forensic IT guy, there have been no files that were deleted. We haven't had a chance to rebut that evidence. We haven't had a chance to demand our own inspection of that laptop. That is by all means disputed. And Mr. Rosslin's representation that there is undisputed evidence that cause occurred, number one, is a fiction. And number two, it is disputed. And number three, the cause issue goes to involuntary withdrawal, which they waived by issuing the K-1. And when you look at 6.3.1, let me pull that up because it's really not so clear as Mr. Rosslin would have the court believe. If the court looks at 6.1.3, which is on page 23 of the operating agreement, or is it 6.3? I'm sorry, 6.3.1. It's a lot to keep up with. Here's the optional buyout event, optional buyout in the event of involuntary withdrawal. This provision jumps right into in the event of an involuntary withdrawal. What no party can point to is when does that event happen? How is that triggered? How is their cause being determined? Who's determining cause? Who is issuing notice? How is it noticed that there has been an involuntary withdrawal? There was never a letter sent to Ms. Ellis saying, we deem that you have acted in a way that constitutes cause and you are now effectively deemed involuntarily withdrawn. No, what happened was she transferred her interest to SYV. SYV then gets a K-1 because it's being treated as a member. Now they can come back and say, no, we were treating it as an unadmitted assignee and merely an economic interest holder, but there is no evidence whatsoever that there was an involuntary withdrawal observed, noticed, anything. So that is just an illegitimate argument. Now, Mr. Rosslin mentioned COVID, I think maybe 10 times as a reason why these distributions were suddenly not made for 2019. The affidavit of Ms. Gould that was submitted August 21st, 2020, after we finally, and my clients had to pay $36,000 to have Ms. Gould sit there because defendants would not send copies or create electronic copies or have a copy service come and just ship everything to my client. The arrangement was only that Ms. Gould had to sit there for 2 days and work with Ms. Brand, and it cost my client $36,000 to get records that SYV should have been entitled to for free. And what those records reveal is that Ms. Brand, during COVID, applied for a PPP loan while paying herself not the $50,000 salary that was contemplated in the operating agreement for management, but $24,601 per month, Your Honor. These payments, this is paragraph 5 of the affidavit, that say there was a catch-up payment made on December 31st, 2019 of $141,509.13. And then beginning January, and that was because they decided, Ms. Brand decided, you know what? Now that we're in such a contentious situation, I'm just going to take all the money out of the company. I'm going to take all the profits, and there's not going to be anything left for a distribution. And I'm going to pay myself the equivalent of $295,000 a year going forward, because I have sole discretion to do that. And SYV is just out of luck. And no one's going to be able to say anything. I am untouchable. And then paragraph 6 of the affidavit shows that Ms. Brand applied for and received a PPP loan in the amount of $42,200. Those funds were received May 7th, 2020. This is in the bank records that were submitted under seal. 8 days after the company paid Ms. Brand $24,601 for April, and 20 days after the proceeds were deposited, that same day, she paid herself another payment, another salary payment of $24,601. So it is just, I can't wrap my head around how Mr. Roslin can argue genuinely that COVID is to blame for the lack of distributions being made when we've submitted. Now, this evidence is undisputed because it's bank records. It's the company's own bank records. They can't come back and say, no, that didn't happen. That's an undisputed fact, Your Honor. So the fact that the distributions are discretionary and she's going to see to it that there's no money left in the company is something that cannot be condoned. We have unavoidable evidence that the tax distribution provision was mandatory. I've already covered that, and I won't I think I've made that point enough times that there was no discretion, and that the notwithstanding provision really hits home the fact that there was no discretion that carries over from other provisions. SYV is indeed a valid member with all the rights that Ms. Ellis had, and therefore the copies that were stored by Ms. Ellis were intended to be transferred rightfully to SYV. You can't point to that and say, oh, that's an undisputed fact constituting cause. Therefore, Ms. Ellis was involuntarily withdrawn as a member. Therefore, SYV never received anything, even though there was a K-1 issued. And going forward for the rest of time, Ms. Brand will be able to decide if and when to ever issue a penny to SYV after allocating 48% of the profits every year. Now, as far as their need for declaratory judgment so that they know if they can just shut it down, Your Honor, we would welcome a shutdown. In fact, we plan on amending the complaint, not only to add the conversion claims that cover the salary payments of $300,000, but we intend to add a claim for seeking judicial dissolution, because this relationship has got to end. And my clients cannot be held hostage on an annual basis for paying this tax liability forever without getting distributions. It's a horrible, horrible relationship. And I don't think there's any question. We tried before this litigation to come to an agreement repeatedly, even after the efforts by Mr. Delisle failed. We tried repeatedly and got nowhere. And Mr. Roslin's response to me, which is in tons of correspondence, is there is no obligation that this relationship end. There is no mandatory buyout provision. There's no mandatory dissolution provision. There's nothing to let your client, SYV, off the hook. And too bad for SYV, they've got to pay this $60,000 tax nut because my client doesn't have to pay anything in this distribution provision. This is just, it's brutal, and it's just never ending.
What do you want me to do? You filed a motion for partial summary judgment. You've also filed something entitled motion for injunctive relief or something to that effect.
The injunctive relief was filed by the defendants, Your Honor.
Okay, I'm sorry.
Our position is
and because it sounds like whatever you want me to do, it leaves part of this case alive.
well, the reason why we moved for partial summary judgment is because there are factual disputes regarding what constitutes a breach of fiduciary duty on both sides. They've alleged that my client breached her fiduciary duty. They've submitted affidavits that create all kinds of issues of fact. We've countered with affidavits that create issues of fact. So I didn't think that I could genuinely ask the court for summary judgment on all claims, although I do believe we now have plenty of evidence for a summary judgment on our conversion claim. And at the same time, defendants are claiming that they are entitled to summary judgment because SYV is not a member and therefore is owed no fiduciary duty. I cited case law in our response to their motion, Marshall versus W.E. Marshall Company, 189 Georgia Appeals 510, that absolutely says that majority owners do owe the minority shareholders a fiduciary duty. It's not just the manager. But as far as what we want the court to do, I can tell you, we need a finding that SYV is a member, not just an economic interest holder. In the alternative, opposing counsel has admitted SYV is an economic interest holder. So ideally, SYV is a member in our estimation. But in either case, whether a member or an unadmitted assignee holding an economic interest only, we would ask the court find that the distribution provision following section 4.2.2.3 is mandatory, that the defendants breached their fiduciary duty by failing to make that distribution, that they be ordered to make that distribution, and that they be ordered to share the books and records on an ongoing basis with SYV until such time as we can obtain a judicial dissolution. Having said all that, we have these other claims that remain.
What are the claims? Why doesn't that do it? You want money, right?
Well, yes, but we have conversion claims now that show that Ms. Brand was retained herself the entirety of the profits of the company. And there is a water flow provision in the operating agreement that has not yet been addressed, but we would need probably Ms. Gould to go through and say, if the $50,000 salary had remained intact as intended by the parties, this is what the profits would be. This is what is a typical reserves that would be appropriate for the company to maintain. And the rest should have been distributed, and SYV would then be entitled to 48%. That is not something that we are able to really obtain summary judgment on at this time because there hasn't been an analysis of those amounts.
Okay.
And then there are other claims. We believe our motion for summary judgment, because Ms. Brand and defendants, whoever, did not make that distribution, we believe we're entitled to summary judgment on the breach of fiduciary duty claim, as well as the conversion claim, even if the conversion was only as to the distribution that wasn't made. We have submitted additional evidence of the conversion of $24,000 a month. But either way, the liability for conversion is there, and then it's a question of damages that can be heard at a later time.
You were entitled to summary judgment on a breach of fiduciary duty for failing to make the distribution.
Correct.
I thought you said just a minute and a half ago that there could be no summary judgment on fiduciary duty since there were still issues of fact.
On their claims, they're claiming Ms. Ellis breached fiduciary duties.
Okay.
So we believe that we're entitled to summary judgment on the breach of contract and breach of duty of good faith. Those are counts 3 and counts 4. And we believe we are entitled to an accounting, which is count 5.
Is there a motion outstanding for that?
Yes, that's all in our, it's part of our response in opposition to their motions for summary judgment.
Okay. So you have a partial summary judgment for SYV's status and distribution on the K1 to pay the taxes.
Correct.
Okay. You have remaining conversion claims, I think. And I guess I'm kind of failing to see what else besides conversion. What do you think the status, and you're telling me, I'm sorry, I'm being so pinballish, but you're telling me that someday we're going to ask that this relationship be dissolved.
Correct.
So you don't think that's in the case now, other than Mr. Rigorish's request for declaration?
That's correct, Your Honor. I think it's come to light, but it was not specifically pled in the complaint as it was filed.
Because and I'm going to let you finish, although we have another case scheduled, and I was actually very interested in this one. I'm sorry, and I should have been more mindful of the time. But here's my bottom line concern: is you've got a 32-page contract. I've never, and I'll confess, it's been at least 40 years of practicing law. I've never met a 32-page contract that didn't have some problem in the reconciliation of all of its various provisions, even when it has severability clauses and everything else. But you got a 32-page contract, which everyone's arguing about the meaning of it. You have a relationship that is over. You've got two divorcing parties trying to live in the same house, which is awful. And you've got now probably 2 years away from a jury trial because of COVID. Because I think everyone acknowledges, and the Ellises need to hear this, and of course, the Brands will, I guess, Ms. Brand. We are facing a crisis with our criminal cases. I mean, we are in a crisis, and it's only getting worse by the minute. And so when we get juries back, we will be swamped with jury trials for at least a year. And so everyone needs to understand that the denial of all these motions, which from a trial judge's point of view is tempting, means years. The granting of anything partial sounds just as bad, unless I'm willing to sign a certificate of immediate review, which probably I would be. So I keep pushing you on this idea of summary judgment, partial summary judgment, because I would love to see this in the posture of it goes one way, it goes the other way, and you appeal it, or we just all wait for another 2 years. So maybe I don't know what I'm asking you, but you see no path to this being over if the court were inclined towards the plaintiffs?
Your Honor, if you're asking me, so what I can say, and this is with all candor that I can muster, is if we could resolve the distribution issue and get that distribution paid to SYV, and we could put that to rest, the other claims, we would be willing to go to a court-ordered mediation to resolve the rest. My clients might even be willing to forfeit other claims, but there has been such venom back and forth, especially with allegations of tampering with the website, We have submitted in response to their motion for injunctive relief, ample evidence of full cooperation by my client. And we believe that the counterclaims that have been filed are an attempt to create smoke and mirrors to deflect away from what defendants have done. I pride myself on not, as a lawyer, in not seeking summary judgment on issues that I think do have genuine issues of material fact. As much as the court might dislike partial summary judgment motions, the clearest issues here in this case are SYV's status as a member, that the transfer was valid, and the failure to make a mandatory distribution to cover taxes. We have seen those as the two major issues from the get-go. The failure, this lawsuit would not have occurred if my client had received that distribution. We wouldn't be here.
Okay. Mr. Rigorous, you're on mute. Are you trying to say, may I respond to that?
Yes, Your Honor, just if I might briefly.
Let me just clarify with Ms. Dutchman, because Mr. Rigorous had a pretty extensive middle part. And I think I've told you, Ms. Dutchman, what I'm interested in and what I'm wrestling with, and I think you've responded to it. In fact, I think you've responded to it well. But let me ask you, is there anything else that you want to say? Because I am going to give Mr. Rigorous about 5 minutes to finish up.
Your Honor, I would point to our motion for partial summary judgment that does in fact ask for summary judgment on several of the counts, including the breach of contract, breach of good faith, and breach of fiduciary duty. So it does resolve a good bit of the claims. Our hope is that if we get to a point of having resolution on those claims, then defendants would be more willing to discuss an amicable resolution. And we just haven't been able to get there without this ruling.
Okay. And thank you very much. Okay, Mr. Rigorous, I'll let you finish up.
Yes, Your
about
Honor.
the time I gave you there.
I understand, Your Honor. The first point is this question about the records and an admission of a breach of the operating agreement, particularly 210-1. They don't get to keep copies of records when they leave. The books and records of the company, it's a subject that's addressed in the operating agreement at paragraph 8.1 and 8.12. You don't take the records with you or take copies, which Mr. Delisle's letter admits they did, and which we think ties into their copying the hard disks of the computer, which is in the affidavit of Mr. Barlow that we filed on Monday. But there's a breach. The point is that SYV under either of these alternatives is not a member. And when it's not a member, and understand the way the declaratory judgment action works, declaratory judgment is going forward. It doesn't address what happened before, which was not paying a distribution. It's conceivable, Your Honor, in this situation that you could grant our declaratory judgment, particularly on the 29A, which we can shut this business down, that SYV is not a member, which means that it can't challenge the business judgments that have been made since, which is what our reply brief filed Monday in affidavits addressed, but still go back to the question of the distribution. That's a conceivable way to divide this up, where we get the declaratory judgment, we get our injunctive relief, which is modified now because the GoDaddy thing has fallen apart. GoDaddy doesn't have the documents we need. What we need to do is get back the documents, including the images of the computers that in violation of the agreement, Ms. Ellis took, and Delisle's letter acknowledges that. If we get our motion for injunctive relief to give us the documents they took, the records they took, including the computer images, and you grant our declaratory judgment, which goes forward, that leaves the tax distribution. We disagree. We don't think there's a right to a tax distribution, but we can break this egg in a way that separates parts and gets this closer to resolution. The way is to grant the injunctive relief governing how we go forward, which is a couple of things. The 29A provision says we can wind this ALC down. They don't have any rights in anything. There won't be any more money. So there won't be any distributions or any allocations to be taxed on going forward. The declaratory judgment makes that go away. Claims plaintiff has raised, as we note in our briefs, are gone. Conversion doesn't work. It's a dollar amount. You don't convert a money amount. That's not the way the conversion works. There's no breach of fiduciary duty because SYV, with the declaratory judgment, isn't a member with any rights to bring a BFD claim against the manager, which is ASC now. So the way to move this case forward, although it does leave our claims against Ms. Ellis, is to grant our declaratory judgment, grant us injunctive relief so we get our records back from which we can conceivably, if she took the GoDaddy operative files, which we believe she did as a part of that, we can then proceed forward. SYV's out of the case. All that's left in the case are our claims against Ms. Ellis, which could very well, there may be an opportunity for resolution there. The obstacle here is us being saddled with SYV without the consent required by the operating agreement. And the misappropriation of our records off the computer put into this RICO storage, which we can't get to, this escrow, which probably includes the GoDaddy files. So if we're looking to get this case in a posture for resolution, it's grant our motions for declaratory judgment, which is forward-looking. That's the nature of declaratory judgment. We need guidance from the court on how to deal going forward. If SYV isn't a member, and we can, under 2.9A, move the business to ASC, which is clear under the agreement, that does away with everything moving forward. And then we're left only with a couple of issues. Miss Ellis's bad behavior, which we have claims against her for, and this question of a distribution that was done before we sought declaratory judgment relief. Now, we think declaratory judgment would entitle us to judgment as well on the claim for that distribution. The court may think differently. You can separate out declaratory judgment, which is looking forward, from something that's happened in the past. Are they inconsistent? We think so. But courts have to resolve matters that are inconsistent all the time. So
why would they have to give the records back?
I'm sorry?
Why would they have to give the records back?
Because 210(1) of the operating agreement says they can't take them. And that if they want to look at records, they come and look at them under 8.1. SYV is not managing the business. They don't get to have copies of the records. They can come look at them.
There are two ways they've gotten them. They've gotten them either through entitlement to them under the operating agreement, or they've gotten them pursuant to a protective order in discovery.
But that's different records, Your Honor. We're talking about the stuff they took off the computers before she left May of last year in violation of 210(1) of the operating agreement. This isn't a question of their access to records, which, that's what Leanne Gould came in, and instead of reviewing the records and trying to identify specifics, she just said, copy everything. So they've, and we believe that was a discovery issue, Your Honor. That's something different. They didn't have if a member wants to come look at records who isn't the manager, under 8.1, they come to the business and look at them. SYV isn't a member with any rights to that. And they clearly didn't have a right, as Delisle indicated in Exhibit B to the complaint, any right to copy and keep stuff. Under 8.1, if they wanted to look at records and you're a member, you come look at records. Instead, they copied them and they kept them and they erased the stuff that was on Miss Ellis's computer. And that's precluding us, because of the things she did with GoDaddy, not renewing stuff in breach of her duties, that's the only place we can get the records. That's where we are now with our motion for injunctive relief. So, Your Honor, I would just say, grant us the injunctive relief we seek, which includes 29A, which tells us what we can do in terms of winding up this business, which was anticipated under the operating agreement in 29A. Find, as we believe is supported, that SYV is not a member, but just an economic interest holder, and that for distributions in the future, that, and we'll, we're going to close down the business under 29A. We have the right to do so. We can close it down. There's not going to be distributions to be made once that gets done. But if going forward on the declaratory judgment that there's no right to a distribution, we can get there. Then we're left with just pay them $66,000 and get rid of SYV's claims. And then we're in the position of, we've got claims against Miss Ellis for the harm she caused.
Your Honor, can I just have a minute? Because
you can have 60 seconds.
okay, you can't have distribution not required in the future, but owe the 66. And there's no guaranteeing that they will shut the company down. So SYV could remain on the hook indefinitely. The motion for injunctive relief specifically asked for my client to cooperate with GoDaddy and transfer the two accounts and any information stored in those accounts, which Ms. Ellis did. There was no mention of these RICO records in the motion for injunctive relief. And there's just being a total conflation of issues here. We didn't get to address the GoDaddy issue, but we have submitted the affidavit of Ms. Ellis, and we will stand by our response to their motion to say that it is completely moot and it was maintained in bad faith. And the website content was left dormant for so long by defendants that it disappeared from the archives. And GoDaddy said that. So the conversion issue, lastly, they keep butchering this concept of conversion, that it can't be for money. That's the most preposterous thing I've ever heard. I've gotten summary judgment for embezzlement from companies of money. That's the whole point of a conversion claim. You can call it embezzlement, you can call it conversion, you can call it theft. But when a person who has access to the money with a right to it, that's a conversion claim, because the funds that belong to the company and should be distributed in accordance with the waterfall are instead being converted by Ms. Brand personally. And we cited the ULQ case for that proposition in our response. But there is no case law that says money cannot be based on you can't have a conversion claim based on a sum of money. That is not what the case represents.
All right.
Your Honor, just on
we could go on and I understand that. Many thoughts have entered my head. I want to go get them all down in just a memo to myself before they leave my head. And I want to thank you all. I think this was, I'm sorry I engaged you so heavily, but this was this was very good work. Thank you.
Thank you, Your Honor.
Thank you.
We're adjourned.